and regulatory requirements define the boundaries within which cybersecurity leaders must operate. They establish minimum standards for protecting information assets, holding organizations accountable for breaches, negligence, or failure to act. Beyond mere compliance, these laws shape executive decision-making by embedding security responsibilities into governance structures. Penalties, sanctions, and reputational risks ensure that organizations take obligations seriously. For CISOs, understanding the legal landscape is not optional. It is foundational to protecting both organizational value and personal liability. Compliance with these requirements reflects maturity, ethics, and commitment to stakeholder trust. Corporate governance and financial oversight laws also play a crucial role in security accountability. The Sarbanes-Oxley Act, SOX, links IT controls directly to financial reporting accuracy, mandating rigorous documentation and testing of systems that influence accounting outcomes. The U.S. Securities and Exchange Commission, SEC, and similar regulators worldwide require disclosures about material cybersecurity risks and incidents. Internal control frameworks now encompass not only financial systems, but also the security mechanisms that safeguard them. Executives, including CISOs and CFOs, bear legal responsibility for maintaining the integrity of these systems. Governance structures that integrate cybersecurity with financial reporting ensure compliance while reinforcing investor confidence. Government and federal security standards establish additional layers of regulatory oversight. The Federal Information Security Management Act, FISMA, sets requirements for safeguarding federal information systems and contractors working with government data. Compliance often hinges on adherence to NIST frameworks and the Risk Management Framework, RMF, ensuring consistent implementation of security controls across agencies. The Federal Risk and Authorization Management Program, FedRAMP, extends these expectations to cloud service providers, creating a standardized path for government adoption of cloud technologies. For defense contractors, the Defense Federal Acquisition Regulation Supplement, DFARS, imposes cybersecurity controls aligned with the NIST SP 800-171 standard. Together, these programs demonstrate how the public sector enforces cybersecurity through contractual and statutory obligations. Employment and labor laws intersect with cybersecurity in critical ways. Organizations must protect employee personal information with the same diligence applied to customer data. Background checks, insider threat monitoring, and access control policies all carry legal implications under privacy and employment statutes. Monitoring and surveillance activities, while often necessary for security, must comply with laws governing workplace privacy and human rights. Aligning HR practices with data protection requirements ensures that security oversight respects employee rights while safeguarding organizational assets. CISOs must collaborate closely with HR and legal teams to balance operational security with ethical and lawful practices. Operating globally introduces unique compliance challenges. Multinational companies often face conflicting regional requirements, such as data localization laws that restrict where information can be stored or processed. Cross-border data transfer regulations, including the EU's standard contractual clauses, SCCs, and new transfer mechanisms, require detailed documentation and due diligence. Nations such as China, Russia, and India impose additional restrictions demanding local storage of certain data types. To navigate these complexities, organizations adopt harmonization strategies, using unified frameworks and standardized controls that satisfy multiple jurisdictions simultaneously. This approach maintains consistency while reducing the friction of operating under disparate regulatory regimes. Intellectual property and digital rights form another key pillar of the legal landscape. Cybersecurity intersects with intellectual property law through the protection of trade secrets, proprietary software, and designs. Legal obligations extend to the proper use of third-party digital assets, including licensed software, open-source components, and creative materials. Copyrights and patents must be respected in both development and deployment of technology solutions. Contracts with employees, vendors, and partners must include clear clauses for intellectual property ownership and confidentiality. By enforcing these safeguards, organizations mitigate the growing threat of intellectual property theft and ensure compliance with both domestic and international IP law. Contractual and civil liability considerations amplify the need for structured governance. Service-level agreements, SLAs, and vendor contracts routinely include specific security and compliance clauses. These agreements define responsibilities for protecting data, maintaining uptime, and reporting incidents. Breaches of contract, especially when tied to negligence or failure to meet agreed security standards, can result in civil penalties and reputational damage. Many organizations embed regulatory language directly into contracts to ensure third parties uphold equivalent obligations. This contractual mirroring transforms compliance from an internal function into a shared accountability model extending across supply chains. Data breach reporting and notification obligations continue to expand globally, demanding speed and precision. Most privacy and cybersecurity laws specify mandatory disclosure timelines, such as 72 hours under the GDPR, and require notification to regulators, affected individuals, or both. Failure to report within these windows can result in significant fines and eroded stakeholder confidence. Incident response plans must incorporate clear reporting triggers and communication templates that align with these requirements. Beyond compliance, transparent reporting demonstrates integrity and professionalism. Organizations that communicate swiftly and accurately after incidents preserve credibility, even amid disruption. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Enforcement and penalties provide the teeth behind regulatory compliance. Regulators possess extensive authority to levy fines, suspend licenses, or impose operating restrictions for noncompliance. Civil lawsuits frequently follow data breaches, alleging negligence or mishandling of sensitive information. In severe cases, criminal charges can be brought against individuals for deliberate or reckless violations of privacy or security laws. However, the reputational fallout often outweighs direct financial penalties. Loss of consumer trust, shareholder confidence, and business partnerships can inflict damage that lasts far longer than any fine. Compliance, therefore, is not simply about avoiding punishment. It is about protecting the organization's long-term reputation and its social license to operate. Executive accountability under law continues to expand as regulators and courts hold leadership personally responsible for governance failures. Board members and senior executives have a legal duty to oversee security and privacy programs with the same diligence applied to financial oversight. A failure to exercise due care can result in regulatory sanctions, shareholder lawsuits, or removal from leadership positions. Legal frameworks such as Sarbanes-Oxley and emerging cybersecurity disclosure rules reinforce that security is an executive function, not merely a technical concern. This heightened scrutiny compels CISOs and general counsel to collaborate closely, ensuring that risk decisions, control gaps, and policy exceptions are disclosed transparently and remediated promptly. Accountability, once abstract, is now codified in law. Legal teams serve as vital partners in risk management. They interpret the nuances of complex regulations, ensuring operational practices align with statutory and contractual requirements. Collaboration between CISOs, compliance officers, and counsel translates regulatory obligations into actionable risk controls. Legal input shapes prioritization, helping organizations determine which gaps pose the most significant exposure in financial, operational, or reputational terms. Risk registers increasingly include legal and regulatory obligations, connecting compliance to enterprise governance. When legal and cybersecurity functions work in harmony, organizations achieve both defensibility and efficiency, meeting legal obligations while improving overall risk posture. Emerging legal trends are reshaping the compliance horizon. Artificial intelligence governance has moved rapidly from policy debate to regulation, with jurisdictions introducing requirements for algorithmic transparency, data fairness, and explainability. Governments are tightening cyber incident disclosure mandates, demanding faster and more detailed reporting. Environmental, social, and governance (ESG) frameworks now explicitly include cybersecurity performance as a dimension of corporate sustainability. Meanwhile, supply chain security has become a legal obligation as regulators require organizations to vet and monitor third-party resilience. These shifts underscore that cybersecurity law is dynamic, continuously expanding to address new technologies, business models, and societal expectations. The interaction between law, ethics, and corporate conduct defines the higher standard of organizational integrity. While legal compliance establishes a minimum threshold, ethics represent the commitment to go beyond it. Codes of conduct that emphasize honesty, fairness, and transparency create a culture of voluntary accountability. By embedding ethical considerations into design, procurement, and data management, organizations reduce the likelihood of legal breaches and reinforce stakeholder trust. Ethical behavior also provides a competitive edge. Customers, investors, and regulators increasingly favor organizations that demonstrate integrity rather than merely legal compliance. Ethics, in effect, becomes a preemptive form of risk mitigation. Continuous legal monitoring ensures that organizations remain aligned with an ever-changing regulatory landscape. Laws evolve, new jurisdictions introduce data protection acts, and international agreements reshape transfer mechanisms. Legal and compliance teams must engage in ongoing horizon scanning, tracking proposed legislation, court rulings, and enforcement actions that could alter obligations. Contracts, privacy notices, and policies should undergo periodic review to maintain currency. This vigilance enables organizations to anticipate rather than react to change, minimizing disruption and avoiding non-compliance surprises. A proactive legal monitoring function is the hallmark of a mature, resilient compliance program. Contracts remain one of the most practical tools for ensuring compliance beyond organizational borders. Vendor agreements, outsourcing contracts, and partnership memoranda define mutual responsibilities for data protection, access control, and reporting. These agreements often mirror regulatory requirements, ensuring that third parties maintain equivalent safeguards. Civil liability clauses and indemnification terms protect organizations from downstream negligence. By embedding compliance into contracts, enterprises extend their governance reach across the supply chain. Each signature becomes a declaration of shared accountability, a reflection of how modern compliance transcends organizational boundaries. The global nature of digital operations means that no organization can address compliance in isolation. International cooperation and harmonization efforts, such as data transfer frameworks between the European Union and the United States, illustrate how governments and industries seek consistency. Multinational organizations often develop global compliance blueprints that align common principles, transparency, accountability, and proportionality across differing local requirements. This strategy reduces operational complexity and prevents contradictions between regional laws. Effective harmonization doesn't erase differences. It builds a coherent structure that ensures compliance wherever the organization operates, fostering efficiency and mutual trust with regulators. CISOs and legal officers increasingly collaborate in the design of security strategies that satisfy both operational and legal imperatives. Security controls must demonstrate due diligence under law while supporting organizational agility and innovation. Legal frameworks, in turn, depend on accurate technical implementation to prove compliance. When governance functions integrate these perspectives, security becomes a seamless expression of law in action, a proactive safeguard that demonstrates responsibility, foresight, and ethical leadership. The most successful organizations are those where legal obligations are not viewed as external constraints, but as integral components of operational excellence. Legal enforcement will continue evolving as technology transforms risk. Governments worldwide are establishing dedicated cyber regulators with powers to investigate, fine, and compel remediation. Directors and CISOs must remain alert to these shifts, understanding that accountability now extends to supply chains, algorithms, and even environmental impacts tied to digital infrastructure. Those who anticipate change by embedding adaptive governance, maintaining strong documentation, and fostering transparency will lead confidently in this new era of legal oversight. In cybersecurity, foresight is the ultimate defense against both attackers and regulators alike. In conclusion, legal and regulatory requirements form the framework through which cybersecurity accountability is defined and enforced. They span privacy, finance, healthcare, defense, and every sector where data drives operations. These obligations compel transparency, enforce discipline, and align corporate governance with societal expectations. Executives, boards, and CISOs share the responsibility for maintaining compliance through continuous monitoring, collaboration, and ethical conduct. In an environment where law evolves as quickly as technology, resilience depends not only on controls but on understanding, the ability to interpret, adapt, and lead within the boundaries of an ever-changing legal landscape.